Thank you. So as Kaya explained, we're going to discuss the one specific aspect of deprivation of nationality, and that is the issue of statelessness. We're focusing only on that, which means that we're not really going to discuss other safeguards against deprivation of nationality. And it's also worth acknowledging that we're going to focus on deprivation of nationality in a narrow sense, and so only as it applies to individuals and mostly within the national security context. I'm going to start by going over the international legal framework, which applies to the determination of statelessness within the deprivation of nationality decision, as well as how this applies to the UK. Patrícia will then discuss the case of Pham in more detail. So under international human rights law, states have a duty to both prevent and reduce statelessness. This duty extends to cases of deprivation of nationality. States should therefore avoid depriving a person of their nationality if this would result in statelessness. For example, we can see the International Law Commission recognizing that neither the loss of nationality nor denationalization should lead to statelessness. In the case of denationalization in particular, there's a general obligation not to denationalize a citizen who does not have any other nationality. Likewise, nationality cannot effectively be lost unless the person concerned has effectively adopted another nationality. In addition, denationalization should not be arbitrary or based on discriminatory grounds. The main legal instrument in regulating statelessness and nationality deprivation is the 1961 Convention on the Reduction of Statelessness. State parties to the 1961 Convention are required by Article 8, Paragraph 1, not to deprive a person of their nationality if such deprivation would render a person stateless. There are a limited exception to this, which are in paragraph 2 and 3. So as you can see, paragraph 2 deals with fraud, and then paragraph 3 deals with issues of disloyalty to the state. When it comes to paragraph 3, there are further limitations to how these exceptions can be applied. So firstly, the exception under paragraph 3 can only be relied on by states that have made a specific declaration to retain the ability to deprive a person of their nationality in these exceptional situations listed, even where they would render the person stateless. Additionally, aside from the declaration, states also need to have these specific grounds for deprivation in their own national law at the time of signature, ratification, or accession to the convention. This latter part of the provision aims to freeze domestic legal frameworks to prevent further subsequent changes to the domestic national legislation from expanding grounds for deprivation after accession to the convention. In accordance to Article 8, Paragraph 3, the United Kingdom has made such a declaration and had these provisions in its national law, so it can indeed use some of these exceptions which are listed. As last month's speaker detailed, the grounds for deprivation of nationality in the British Nationality Act are listed in section 40. There's one ground here that allows to deprive an individual, even if it renders them stateless, if it's deemed conducive to the public good. This clause goes back to the Immigration Act of 2014, where the UK extended its power of deprivation to allow the Secretary of State to deprive persons of their British citizenship on character grounds, where this should leave them stateless, provided that the Secretary of State had reasonable grounds to believe that the person is able to become a national of another country. And so this specific wording, being able to become a national of another country, as last month's speaker pointed out, seems to go back directly to the government's failed appeal in the Huyghe case at the British Supreme Court. So just to be clear, up to 2002, the UK did have a provision which allowed for deprivation of nationality resulting in statelessness in line with the declarations it made to the 1961 Convention. This was then repealed. And so between 2002 and 2014, there were no grounds in British law to deprive somebody of nationality if it rendered them stateless. The changes passed in the 2014 Immigration Act just means that the legislation reverted back to its 2002 position. And so if we think back on the idea of freezing national legislation, as contained in Article 8, Paragraph 3 of the Convention, we can see that that was achieved. However, this freezing does not prevent amelioration in legislation which provide more safeguards against statelessness from sliding back to what the domestic legislation was at the time of accession to the convention. It's interesting to look at what the Human Rights Joint Committee of the British Parliament was saying ahead of the 2014 changes. We can see consideration of the impact of the reintroduction of deprivation leading to statelessness. Firstly, the Joint Committee considers the obligations of the UK under the 1916 Convention. So they say, we accept the government's argument that in strict legal terms, enacting the power in Clause 60 to deprive a naturalized citizen of their citizenship, even if it renders them stateless, does not involve any breach of the UK of its obligation under the UN Conventions on Statelessness. The new power will lead to an increase in statelessness, which represents a significant change in position in the human rights policy of the UK, which has historically been a champion of global efforts to reduce statelessness. It does not per se, however, put the UK in breach of any of its international obligations in relation to statelessness. The Joint Committee then turns to the UK's broader obligations under international law, including human rights law. Here the discussion is slightly longer, but in summary, the Joint Committee questions the purpose of the bill. Specifically, if the sole purpose of the bill is to deprive naturalized Britons while they are abroad, they think the amendment could be in breach of international law. They conclude, we would be very concerned if the government's main and sole purpose in taking this power is to exercise it in relation to naturalized British citizens while they're abroad, as it appears that this carries a very significant risk of breaching the UK's international obligation to the states who admitted the British citizen to its territory. So this brings us to the broader international law and human rights law considerations at play. ISI's principles on deprivation of nationality in a national security context are very clear that within this broader legal framework, states must not render persons stateless through the deprivation of nationality, and that really is the golden standard. However, if we look at UNHCR, which has been granted a formal mandate to prevent and reduce statelessness by the United Nations General Assembly, in their guidance on issues of deprivation of nationality, they don't quite meet this golden standard laid out in ISI's principles. UNHCR finds instead that given the severity of the consequences where statelessness results, deprivation which leads to statelessness can only be considered proportionate in limited and narrow circumstances. States must interpret Article 8, paragraph 2 and 3 narrowly and in accordance with international human rights obligations. They should seek less intrusive means to achieving their legitimate aims, for example, through extradition or prosecution. If we think of the severity of the measure and if we try to assess the proportionality of deprivation decisions, it's important to keep in mind the specific harms resulting from statelessness on top of the harms that stem from the loss of one's nationality. Individuals who are stateless face the risk of rights violations every day, from destitution and denial of basic services to immigration detention. The assessment of the consequences of a deprivation order should therefore always be considered whether the individual would be rendered stateless by the deprivation. But it should also take into account the derivative impacts on children and families of the person deprived of nationality, whether these impacts are direct or indirect. So in international law, and in particularly the opinion of the Committee of the Rights of the Child, prohibit derivative loss of nationality, and states should ensure that children's nationality isn't affected by their parents' loss of nationality. However, if children are not themselves deprived of their nationality, their parent is rendered stateless, this may still have a significant impact on the child's private and family life and on the ability of the child to enjoy the rights that are attached to nationality. Thinking of the context in which most British nationals are deprived of their nationality and left stateless in recent years, it's a context of the individuals and families who are in some way thought to be associated with armed groups such as ISIS. These individuals were deprived of their British nationality while in Syria or elsewhere abroad, and many remain there in different forms of detention, whether it be in camps or jails. The decision to deprive them has often left them stateless, and they are effectively permanently deprived of access to consular assistance, which they urgently need in the situation where they're in. They also no longer have a place to be repatriated to, and so the question of when and how their detention ends can't be answered. It's important here to keep in mind the conditions of their detention. So UN experts have found that the conditions in the camps in which they are constitute cruel, inhumane, and degrading treatment and may even amount to torture, and also that the terms of their detention are arbitrary. If we look at research by Reprieve, you can see that the UK has deprived most of its nationals who are now detained in Northeast Syria of their nationality. Children in this situation are detained alongside their mothers. It's unclear if the UK government has considered the nationality of the children when they made the decision to deprive their mom. Yet these impacts on the children are substantial. And I'm just going to give two quick examples of how children can be impacted by the deprivation of nationality of their mother if it leaves her stateless. So if children are British or have obtained their father's nationality at birth, so when I say they are British, they have obtained British nationality when they were born, or they have the nationality of their fathers automatically at birth. They would no longer be able to legally reside in the same country as their mother if she was rendered stateless by the decision to deprive. Of course, this issue can also arise if the mother is not left stateless but retains a nationality of a state that does not automatically get passed down to her children. Basically, this means that even though these children could be repatriated, repatriation would also automatically mean forced separation from their mother, who in this scenario is often their sole carer. Second scenario is if a woman has children after being rendered stateless as a result of being deprived of her British citizenship. Her children will not obtain British nationality in this scenario. And so we can see from Reprieve's research that the UK government has deprived one woman while she was pregnant. The nationality status of her child is not known because we don't have any information on the father, or there's no public information about the father. Another scenario would be if the mother is deprived, has a child, and the father of the child is absent or is stateless or can't pass down his nationality to his child because of discriminatory legislation in his country. We unfortunately all know an example of a case like that. Shamia Begum's youngest child was born after she was deprived, and his father is a Dutch citizen who would not automatically have been able to give his nationality to the child. So these examples are just to show that the impact of the decision to deprive, especially when it renders somebody stateless, has wider consequences for children, which states should really take into consideration before issuing a deprivation order. So Patrícia will now continue to discuss how all these different obligations play out in Pham.
Thanks, Alison, and good afternoon, everyone. Thanks for being here today as well. And thank you to ISI for inviting us to speak. It really is a pleasure to be here and to be sharing about this topic. Well, Alison has already spoken about why it is important to assess whether the individual would be rendered stateless by a deprivation order. And that's both based on international law, but also given the severe consequences of statelessness. And I will now briefly discuss when and how that assessment should be conducted. So in assessing statelessness in deprivation of nationality, states should first of all carry the burden of proving that loss or deprivation of nationality will not result in statelessness. And this is something that was stated by the UN Secretary General on Human Rights and Arbitrary Deprivation, but there are actually already some SIA cases that have also put the burden of proof on the state or the Secretary of State, in this case in the UK. There is also UNHCR guidance that says that it is that in order to comply with international law, states should conduct the assessment of the risk of statelessness before issuing a deprivation order. And whether an individual will be rendered stateless through withdrawal of nationality is a question of whether the individual is currently recognized as a national by any other state and actually has proof of that nationality. So in order to make sure that all of these steps are taken and these elements are fulfilled, there are a few steps that the authorities must take before depriving an individual of their nationality. And this is all considering the definition of a stateless person, which goes back to the 1954 convention. So although we're talking about prevention and reduction of statelessness, which is under the 1961 convention, when we're applying the definition of stateless person, we revert to the 1954, which is the definition recognized internationally and under customary international law as well. So under Article 1, it's, a stateless person is someone who is not considered as a national by any state under the operation of its law. And this really is the key concept here. So this definition encompasses an analysis of how the competent authorities apply the law in practice. So both the letter of the law and the factual circumstances are relevant to the conclusion that the person is stateless. And so, for example, arbitrary discriminatory practices by the competent authorities in what would be the state of nationality also play into account here. This is an issue that is still very much live in British courts. So again, I mean, I will be talking about the Pham case, but for example, Sharima Begum's case, which is quite famous as well, there was also an issue whether the SIA considered how the Supreme Court of Bangladesh should interpret Bangladesh nationality law before considering the issue of state practice, and ultimately found that Ms. Begum was not de jure stateless, and therefore the deprivation decision had not made her stateless. And we have seen this in a number of other UK cases on deprivation of nationality, where the British courts decide themselves whether a person is stateless in accordance with the laws of another country. But this is entirely against international law and guidance as well. And the use of the concept of de facto stateless is very dangerous, and it risks excluding stateless persons from protection of the statelessness conventions based on a misreading of the definition of statelessness. So according to international law, including the 1930 Hague Convention, it is for each state to determine under its own laws who are its nationals. And any question as to whether a person possesses the nationality of a particular state shall be determined in accordance with the laws of that state. And it is therefore essential to have clear and precise information from the state with which the person may have any connection to ensure that the individual would not be rendered stateless or at risk of statelessness by the deprivation. And the determination of whether the person is recognized as a national should not be based on a state's interpretation of another state's nationality laws, but rather be informed by consultations with the authorities of that state, and the decision maker should seek written confirmation from the state about the nationality status of that person. And what that state will say in response to those inquiries is also not the end of an investigation. Practice must also be considered, and that includes an analysis of how the authorities are applying the law in practice in a specific case. And this is very clearly stated by UNHCR in the guidelines on statelessness number 5 as well. And I have inserted a quotation here. So it says essentially that where the competent authorities treat an individual as a non-national, even though he or she would appear to meet the criteria for automatic acquisition of nationality under the operation of a country's laws, it is their position rather than the letter of the law that is determinative in concluding that a state does not consider such an individual as a national. And even though this is from a section of the guidance that applies to acquisition of nationality, the same assessment applies to situations of deprivation. So we're bringing here the example of Pham to show you how these international norms and guidance play out in practice and what the consequences may be when they are not followed. And this, we're presenting this case today because you might have heard of Pham in the context of the UK Supreme Court. There was quite a famous judgment from 2015, but then further to that, the case also progressed in the British courts, and it is currently before the European Court of Human Rights. And in March this year, the European Network on Statelessness and the AIR Centre submitted a third-party intervention before the European Court of Human Rights on the case of Pham, and the case is still pending, but we're also bringing you here some of the analysis that we presented to the court. I should be clear that we did not analyze the balance between national security interests and citizenship, nor any wider issues related with deprivation of citizenship. And today I will also not expand on those issues. Our focus is very specifically on the assessment of whether someone would be rendered stateless by a decision to deprive them of nationality. And so this Pham happens to be the case that is currently before the European Court of Human Rights, but it could also apply to many other cases that are currently before the UK courts. So Mr. Pham was born in Vietnam, and he acquired British nationality by naturalization in 1995, when he was around 12 years old. Then in 2011, the Secretary of State decided to deprive him of his British nationality following an assessment that he was involved in terrorism-related activities. And she was satisfied that this would be conducive to the public good, which is what the British Nationality Act requires. You should also note here that the decision to deprive Mr. Pham of his British nationality was in 2011. So this was in the period where the British Nationality Act did not allow for deprivation to result in statelessness in any circumstances. The Secretary of State considered that the order would not make him stateless because he would have retained his Vietnamese citizenship. But so she made this order, and the order was served on the appellant on the same day. And although there was evidence of some discussions between the British and the Vietnamese governments that had started a few months before, there was no information about the identity, date, or place of birth communicated to the Vietnamese government. And after Mr. Pham had been deprived of his nationality, the Vietnamese government has never considered, it had never considered the question of whether he was a Vietnamese citizen. And even after he had been deprived, the Vietnamese government still never confirmed whether Mr. Pham is a Vietnamese citizen or was a Vietnamese citizen at the time of the deprivation. So there was never a statement from the Vietnamese government confirming his nationality status. And this case represents very well the danger of referring to de facto statelessness. So the British government considers Mr. Pham to be Vietnamese, even though Vietnam refuses to acknowledge him as a citizen. Effectively, he has no country to return to and no consular protection from any state. So Mr. Pham is stateless under the operation of Vietnamese law. And when states distinguish de jure and de facto statelessness, they are effectively departing from the definition of a stateless person under the 1954 Convention. And that also encompasses the practice of the authorities, as we've seen. So even if the government of the foreign state chooses to act contrary to its own law, by refusing to recognize the nationality of a person who, according to its law, should be national, that person is still stateless. And that is exactly the meaning of under the operation of its law. Any different interpretation would revert the object and purpose of the Statelessness Conventions, which is precisely to protect stateless people and prevent statelessness, even when their own country acts against the rule of law. So as I mentioned, after the Supreme Court judgment from 2015, the case was remitted back to SIAC, and then it made its way up the UK courts. And then Mr. Pham submitted an application to the European Court of Human Rights, claiming that his right to private and family life has been violated. So what can the European Court of Human Rights say about this? And the relevant article here is Article 8, which protects the right to respectful private and family life. And under Article 8, the court, and whenever I say the court from here on, I'm referring to the European Court of Human Rights. So the court has reiterated that a right to a nationality or a right to acquire or retain a particular nationality are not necessarily guaranteed by the convention or its protocols, but it has also confirmed on several instances that any interferences with a person's right to a nationality may engage Article 8 because of the impact that it has on the private life of the individual. And the position of the court regarding acquisition and loss of nationality is really a patchwork of different cases. It is not always consistent and clear, but there are some elements that we can already build on, and I will very briefly guide you through them. But essentially, in two cases, in Genovese and Karasev, the court confirmed that a denial of nationality can result in a violation of Article 8. Then it accepted that the same principles must also apply to the revocation of a citizenship that was already acquired, in the case of Ramadan. And then in more recent cases, the court has kept on stating that although the right to nationality is not as such guaranteed by the convention, arbitrary deprivation of nationality may engage Article 8. And so the court has established nationality is an element of personal identity, and that deprivation may constitute an interference with a person's right to respect for private life. And if deprivation results in statelessness, we consider that there will always be an interference with a person's right to private life. So therefore, deprivation attracts the procedural safeguards of Article 8, and it means that any deprivation of nationality which may result in statelessness needs to be justifiable under paragraph 2 of Article 8. Under this provision, any interference with the right to respect for private and family life must be in accordance with the law and necessary in a democratic society, for example, in the interest of national security. So for a deprivation order to be considered in accordance with the law, it must have regard both to the relevant domestic provisions and to the international law that is applicable to that state. So in the case of the UK, it must comply with the British Nationality Act, as well as the Article 8 of the 1961 Convention, and the international definition of a stateless person, that is the one that we saw from the 1954 Convention. And the notion of being in accordance with the law also includes the quality of the law. And the quality of the law implies that the decision must not be arbitrary and should also follow adequate procedural safeguards, and that the authorities act diligently in each case. So all of this is also part of Article 8. Then the analysis of whether deprivation was necessary includes a fair balance between the applicant's right to respect for private and family life, which is strikingly at stake if it results in statelessness, and any other competing authorities, including, for example, national security. And it also includes an assessment of the proportionality of that measure. Unfortunately, the court has so far not yet provided a clear standard to assess whether deprivation of nationality in a particular case has led to a violation of Article 8. And the few judgments that have been issued on this actually departed from the usual tests applied by Article 8, but the court is still developing this, and we really hope that it can be clarified in future case law. The truth is that due to the severe consequences of statelessness, and Alison has very well explained them already, an assessment of whether a deprivation of nationality amounts to a breach of Article 8 must always take into account whether the applicant was rendered stateless or at risk of statelessness by the deprivation. And it must also include an analysis of any impact it might have on the applicant's family. So a thorough assessment of the applicant's particular circumstances should be conducted by the state before imposing any measures which may affect the applicant's right. So any investigations with the other authorities, with the authorities of the foreign state, should be conducted before the state deprives an individual of the nationality. Then the long-term adverse repercussions of statelessness and the consequences that it may have in the enjoyment of a person's fundamental rights must also have significant weight in any deprivation decision. And we know that according to international law and guidance, this determination should always be conducted before, again, the deprivation decision. So I'm not exactly sure what will happen in the case of Pham. We're very curious and we will wait. We might still be waiting for a while until the court issues a judgment here. But there are also similar cases across Europe raising the same questions. And I think that one of the key questions that the European Court of Human Rights must essentially answer here is whether Article 8 can in itself protect against deprivation when it results in statelessness, given the severity of the consequences associated with it. So just to finalize, what we're really advocating for here is a human rights approach to deprivation. And while doing so, we do have a basis to claim this. So we know that Article 53 of the European Convention of Human Rights requires states not to fall below the applicable international standards in complying with their substantive and their procedural obligations under the European Convention of Human Rights. And this is an exercise that we're already used to do, because we know that it is critical to look at international law as a collective body of standards that together establish the level of protection granted to an individual. So Article 8 comes therefore attached with states' obligations to prevent and reduce statelessness. And we can no longer simply look at the declaration made by the UK to the 1961 Convention to conclude that it is lawful to render a person stateless by a deprivation order. The provisions of UK law on deprivation must be interpreted in the context of the European Convention on Human Rights and other human rights instruments as well. And even though today there are circumstances in British law in which a person may be rendered stateless by a decision to deprive them of nationality, the test that I mentioned here today is still highly relevant in all cases, as statelessness and its consequences must always be weighted in the assessment of whether the interference with the right to private life is necessary and proportionate. In fact, and as we know, the ISI principles on deprivation of nationality reiterate that states must not render persons stateless through the deprivation of nationality, ever. And this is particularly relevant at a time when there is a growing concern about trends across Europe to deprive persons of their nationality on national security grounds. And we know from our own investigations, our own research at ENS, that at least 9 European countries have expanded their citizenship stripping powers since 2010. And therefore, in the future, the European Court of Human Rights does have a key role to play here as well, to ensure that compliance of human rights is guaranteed across all of these deprivation decisions.